Welcome to When Family Matters Become Legal Matters.
Hey, everybody. Welcome to When Family Matters Become Legal Matters, where we help you navigate the legal steps needed to protect your family, your future, and your legacy. I'm your host, Mike Leon. I'm joined here by Betsy Holton, the founder of Holton Law Group, who has years of experience guiding families through estate planning, elder law, and special needs planning. And Betsy's going to share the practical advice and trusted strategies that turn these complicated legal issues into peace of mind for everybody. So Betsy, let's get into these estate planning myths and kind of breaking some of this, the myths of what you think you know, but might not know. So what are some of the most harmful myths that you hear about estate planning, and how do they lead people astray?
Absolutely. Thanks, Leon, Michael, for having me today. And we are going to talk about these myths, right? The first myth that everyone just across the board believes in is that estate planning is only for the rich, because they hear the word estate. And so they're thinking there must need to be a lot of money involved. But people do not realize that your estate is just the legal term for the things that you have, your stuff, right? And so whether you have a little bit of stuff or a lot of stuff, you need to have a plan. And I got to a point where I started telling people, well, there's some statistics out there that say only about 25 to 30% of Americans have estate plans. But that's not true. Every American actually has an estate plan. The question is, do you have an estate plan that works? And do you have an estate plan that works the way that you want it to? Because if you become incapacitated, the state has a plan. It's called guardianship. If you die, the state has a plan. It's called intestate succession. So you can either have your family go through whatever process the state wants you to go through, or you can go through a process that you put in place that does what you want it to do sometimes without the court. The other myth about it only being for the wealthy is that people feel like if I need to do a trust, because people always assume that estate planning is only about a trust, then they feel that they don't need to take care of that because they don't have large amounts of money that need to be in a trust. Because we hear words like, oh, they're a trust fund baby. Hamilton made that very popular.
Mm-hmm.
So but that's not really the case. The fact of the matter is, when you pass away and you have assets, stuff, it needs to go to someone else. And there are certain assets, particularly real estate and some other assets, that cannot be given away without court intervention. So the first myth the second myth, after people thinking that it's only for the wealthy, is that it's only this elaborate trust that needs to encompass a large estate. When the fact of the matter is, an estate plan encompasses much more than just a trust. You can have an estate plan with just a will. And one of the things about the will that's so great is that, remember, we talked about this intestate succession plan that the state already has for you. Well, that plan may not be the plan that you want, right? So you have the ability to set up a will that puts together a plan exactly as you want it. The intestate plan with the state also does not provide any type of language or provisions for minor children. So if you have minor children, if you set up a will, you can at least talk about how you want to set up guardianship or things of that nature for your children in your will. But some of the other documents that are part of the estate plan, which are also so important, are a durable power of attorney to allow someone to handle your finances if you become incapacitated, a medical power of attorney that allows someone to assist you when you cannot make medical decisions for yourself, and a HIPAA authorization to allow people to communicate with your physicians, your medical providers, as well as a living will to let someone know what your final wishes are about the level of care that you want to receive in your final days. Those are the documents that make up an entire plan. And so when people believe that it's only this elaborate trust, they tend to think that it then becomes into myth number three, I think we're on, which is that it's only for older people. An
Right.
estate plan is actually for anyone who's over the age of 18. Because once you are over the age of 18 in almost every state in the United States, you are considered an adult, and mom and dad no longer are the persons who are automatically in charge of taking care of your affairs. So if you're 18 and you happen to get into a really bad accident and you have a job or you have responsibilities, guess what? We now have to go to court to determine who's going to handle your matters and handle your affairs for you. But if you have a proper estate plan, even though it doesn't deal with a whole lot of assets, although there are a lot of 18-year-olds out here with AI and some of this other stuff, and they're making real good money. But even if you don't happen to have a lot of assets, they still need to know who's in charge. And so you don't want to have to send your family to court to have the judge make that decision for you. So, another myth that people have is that they feel like estate planning isn't really necessary, that they can just, if something happens to them, all their stuff's going to go where they want it to go. And that's not true. Because let's say you're only 25 years old and you happen to be a little estranged from your parents. Did you know that if you pass away and you don't have any children of your own, that all of your assets go to your parents? Most 25 or 30-year-olds don't think about that. And I can't imagine not wanting my parents to receive my assets, but there are a lot of people who just really do not have relationships with their parents and would much rather for that to go to someone that they've interacted with on, a regular basis, or someone that they feel would be in a better position to receive that.
And Betsy, it's perfect into the follow-ups because something that you mentioned there, I want to go back and I would love for you to expand on, which is why it's just as important for families with these modest incomes or simple assets to do estate planning. And is it just simply because the state is going to implement that plan that we talked about? Is that the reason beyond that? Because you don't know where the assets will go or where they'll be disseminated to.
Right, right. Not only that, when the state has to do it, it takes a long time and everything is frozen. And so when you put a plan into place, you avoid the time, the expense, the possible conflict that comes up with having to go through the court process. I can tell you that even in a very simple estate, even if I have a will, it's going to take much, much longer if I don't have a will. But even if I have a will, we're looking at 8, 9 months. That's with everyone turning in every piece of paper as soon as I ask for it, getting it filed with the court as soon as I can get it filed, and the court giving us a court date as soon as the court has an availability. So from the date of death for 8 to 10 months, everything is tied up. That's not really the optimal plan for anyone. So, having a proper plan to avoid that not only saves money, but it saves a lot of time. I can tell you one of the hardest parts of my job is when we're going through this probate process. And every time I have to ask my clients, can you please go and look and see if you can find this document? Can you find information about this asset? These are times where we are reopening wounds of grief for the loved one and the person who's left behind to handle the affairs. That is not what most people who try to put a plan together, or even people who have neglected to put a plan together, I'm sure that's not what most people would want. If you took a survey and you asked everyone, hey, would you like for all of your relatives to suffer through not only the grief of your loss, but also having to wrap up all your affairs, be tied up in court and running around trying to take care of your affairs? Or would you like to have a plan that eliminates everything but as much of everything but the grief? right? And that is probably going into myth number 4, which is that it's okay, I don't need a plan, but because everything's just going to go where I need it to go. But you really want to make sure that you are providing your loved ones and those that you leave behind with a conflict-free way to manage those affairs for you.
Yeah. So, and it's funny, but my dad always repeats the plan to me every single time, and I'm like, Dad, this is morbid. I don't want to have this conversation. But I do want to stay on something that you mentioned earlier. I would love for you to expand a little bit more. Is that even if you don't have a child, you should still have a plan. Can you explain further why that is so paramount for folks out there?
Yes, yes. So in almost every state, the intestate succession typically goes this way. We look to see if you have any biological heirs. Okay. And so those will be the people who typically take your assets. If you don't have those biological heirs, then the intestate succession plan goes back up to your parents. Well, what if your parents are deceased also? Okay. So now the intestate succession plan goes out to your parents first, then it goes out to your siblings. If you don't have siblings, then it goes back up to your parents, to their siblings. It could take a long time. There are professional genealogists who will go through a very long and expensive process to find out where your assets need to go if you don't have a plan. When your best bud from college may have been the perfect person to list in your plan, and none of that would have had to happen. So it's very important. And also, when you don't have children, it's even more difficult to figure out where those assets would go. Again, that would sometimes require a professional to come in and make that decision as to where the assets have to go, because they have to go somewhere.
Betsy, a lot of the times you see people use these online templates or these do-it-yourself wills. Can you kind of get into, the risk associated with that, if that's even sufficient enough to do in the court's eyes or in the law's eyes?
Yeah, so in the eyes of the court, if you can go to an online source and prepare a will, I will tell you this: it is better than having nothing. For instance, here in the state of Texas, if you do not have a will at all, a, an attorney ad litem, a third party, comes in appointed by the court, and they have to make a determination as to who your heirs are. Okay. That is an additional process and an additional cost. At least if you have a will that you've attempted to do online, where you just filled in the blanks, it does kind of show what we call testamentary intent was. And if it follows the rules, it's signed in front of two witnesses, it's signed in front of a notary, so that the two witnesses are saying, we saw you and you appear to be of sound mind, sign this will, the court's probably going to admit it. But here's where we run into a problem with those. Unfortunately, and I don't know why, but it just seems that whenever we have these fill in the blank online wills, they become contradictory or somewhat ambiguous. And so now we're trying to figure out, how do we resolve this conflict, because the language doesn't flow properly,
Right.
right? So we talked in another podcast one day about blended families. And you tried to put together this online will that was going to account for your children, but you didn't realize that the children were not yours, because, well, you knew that, but in the will, there's no designation on this online will of these children who are not your biological children. Well, the court is bound by the statute, and the statute says that your children are your biological heirs. So now you've created a conflict, because if you haven't named them, I mean, and we're getting into the weeds here, but if you haven't specifically named them and you've just left this large category as just children, the blended children are not included.
Right.
Okay. So there are times that you make these fill in the blank answers that don't answer your questions, so that when the document is presented to the court to be processed, I guess that's a good word to use. If I said probated, it kind of makes it more confusing. But if you present it to the court to be processed, now the court is trying to decide, how am I going to reconcile what you have written on this paper with what the laws of the state tell me I'm supposed to do, because there's somewhat of a conflict there. But I will tell you that, and I tell people this all the time, I'd rather for you to even try to do it yourself than not doing anything at all, because not having anything at all absolutely puts you in a position where only the state rule can apply. And if you know that that's not the direction that you want your family to go in, it is better to at least attempt to do the online form. But most of the lawyers are really good about trying to keep this reasonably priced for you so that you can have it done properly.
So, Betsy, somebody's watching or listening to this and they go, it's too complicated. It's too stressful. I don't want to do this. Stress to them why they need to have this stuff in place.
So, unless you're just really a narcissist and you don't want your family to have to go through, imagine how stressful it is for the family member that's left to deal with it if you don't take care of it now. It's not that difficult. Most of the program, even the online programs, they just ask you questions, a succession of questions about, what do you have? Who do you want it to go to? How do you think about this? What would you like to have happen in that scenario? So it really is not that difficult. And we work really hard to try to eliminate all of that by providing very simple online intake forms. There are lots of inventory books. There's tons of stuff on the internet that can at least get you organized, so that when you sit down to make your plan, it's literally, what do I have? Who do I want it to go to? And who do I want to be in charge of making sure that happens? It's really that simple. And the amount of excess worry, stress, and potential conflict that you avoid for your family members will give you an extra sense or peace of mind, because they don't have to go through that hard, we got to try to find all this stuff. We have to try to figure out, and we have digital assets now. It's so much more involved in this process now than it was, say, 20 years ago when I first started doing this. So it's much easier to do it now than to have your family do it later.
And the relief part of this, like you just mentioned, once the clients that you've dealt with, once they've put a plan in place, how do you see them now all of a sudden being kind of relieved? Do you see it shifting the family dynamics at all?
Absolutely, absolutely. And I've had people come to me and said, one of the things we do is the people that you put in charge when you're either passed or incapacitated, we send them a letter and let them know that that's their new role. And I've had people come back and tell me, my daughter was really happy that I had taken care of this. And so now I can feel comfortable that she's not going to be burdened with having to deal with my affairs, because she's going to miss me, I'm sure. So she at least won't be burdened with having to deal with my affairs. I get that all the time. Absolutely.
Yeah. Well, Betsy, thank you so much for the insights and analysis on this. We truly appreciate it.
Sure. It's been a pleasure.
And thank you, everybody, for listening to the show today. Do us a favor. Please subscribe, review, share the show if it feels like it'll help you or somebody you know. If you want to contact Betsy and for more resources or connect with the Holton Law Group, do me a favor, visit holtonlawgroupfl.com. If you live in the state of Texas, visit DFW, the letters DFW, trustandwills.com. That's it for us. I'm Mike Leon. Thanks for watching.
Thanks a lot.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.